we go on the record, I've got a couple of questions for people. Jan Reed?
Yes.
Jan, Mr. Reed. Coast Economic Consulting, what's your interest in this proceeding?
I'm a PG&E ratepayer, and I'm interested in the parts of the proceeding that could have an effect on PG&E ratepayers. For example, as IEP has pointed out, anything that happens with songs could have an impact on PG&E ratepayers, whether it's continued, whether it's shut down. There's also, if God forbid there were an accident, of course that would affect PG&E ratepayers.
And how do you intend to participate?
I intend to participate by writing testimony, attending workshops, if any, comments, briefs, doing discovery, etc.
Okay.
Full range.
All right. Mr. Cummins?
Yes, Your Honor.
Where are you? Federal Executive Agencies, what is this? Can you tell me what your interest is in the proceeding?
Well, the federal executive agencies are ratepayers at various locations. And
within the Edison territory? Or?
Correct. Navy bases, Army, Air Force,
okay.
NASA.
And Mona Tierney? Tierney
yes,
Lloyd?
Sarah Myers, I put in an appearance for Internoc as well as the Center for Energy Efficiency and Renewable Technologies. Ms. Tierney Lloyd could not be here today, so there's another appearance slip before I see
that one. What is Internoc?
Internoc is a demand response provider in California and the United States. The Center for Energy Efficiency and Renewable Technology is an advocate for clean energy solutions in California. Actually, we have put in, both parties have put in for party status, but I actually needed a clarification that went with that. Both CERT and Internoc are interested in how resources, if there's going to be consideration in this investigation of replacement resources, and if that happens, or if this serves as an umbrella proceeding to determine when and where that happens, we have a very direct interest and concern to make sure that the right resources are selected, and we would participate actively through comments, workshops, briefs, and testimony. Thank you.
Okay. Yeah, I know. Okay, good morning. Let's go on the record. We do have a court reporter. The commission will come to order. Today's date is January 8th, 2013. This is the time and place for the pre-hearing conference for the order instituting investigation regarding the San Onofre Nuclear Generating Station Units 2 and 3, known as Investigation 12-10-013. I am Melanie Darling. I'm the assigned administrative law judge in this matter, and Commissioner Florio is the assigned commissioner who is presiding with me today. I have passed out an agenda to sort of give you an idea where we're going today. The commissioner and I have had some extensive conversations about how we see this OII unfolding. We expect a number of issues to be added along the way. We've given some thought to how to organize those in a way that builds a record successively for each set of issues that comes forward. We're going to outline our general thoughts today and then ask for your comments about that. This is basically a result of what happened during the fall of 2012 when Edison notified the Commission that Units 2 and 3 have had unplanned outages for 9 or more consecutive months due to operational problems arising from the previously approved steam generator replacement project. As a result, this OII was initiated to determine, among other things, whether the value of any SONGS facilities should be removed from rate base as no longer used and useful, and if any post-outage SONGS-related costs should be excluded from the revenue requirement. We have an intent to look at all SONGS-related costs that are impacted by this shutdown. We'll discuss this in more detail a little bit later on in the agenda. What this OII will not consider is whether Edison is authorized pursuant to its operating license to restart Unit 2 at partial power or either unit at any level. This is the jurisdiction of the Nuclear Regulatory Commission. Also, questions about the future operations of SONGS we believe is most appropriate to be considered in the long-term procurement planning proceeding and not this OII. Furthermore, it's not our intention to review specific proposals for future procurement by energy producers in this proceeding. Some of these matters have yet to be filed that we are looking at. The 2012 GRC directed the 2012 costs to be moved into this OII for review. The steam generator replacement project, the repair options, and the allocation of those costs. The 2013 era that would be looking at the 2012 procurement costs. Those are the kinds of issues that were outlined, identified in the OII, and which we intend to fold into this proceeding. Today, it's not our intention to make any final rulings about how this scope is going to break up or the timing of the proceeding. Instead, we're going to listen to your comments on these matters, and we will be promptly working on a scoping ruling in the near future that will address Phase 1. At this time, I'd like to turn it over to Commissioner Florio, who has some comments to share with you this morning.
Welcome, everyone. We apologize for the cramped quarters. The San Bruno hearing occupied room A. I'm not sure that was the right allocation of resources, but we live with what we get. This is going to be a long and difficult proceeding. The Commission has some weighty matters to look at here, the full scope of which is probably not yet clear. We're hoping to have an orderly proceeding and reach a fair resolution on these issues. And despite the cramped quarters, I hope we can make real progress today in getting started on that. ALJ Darling will be the presiding officer and will be running the proceeding, and I will be keeping a close eye on what goes on here, but look to her for procedural rulings and things of that nature, and try not to waylay me in the hallway too often about this proceeding. Thank you.
Okay. The first thing that we are tasked with doing today is making sure that we have an accurate service list identifying parties and others who wish to be on the service list. I've previously granted motions of party status to a number of organizations. Other organizations that have come here today have filled out these forms. Before we were on the record, I did ask a couple of clarifying questions about their intent to participate and their interest in this proceeding. At this time, I would like to go ahead and grant party status to Southern California Generation Coalition, to the Utility Reform Network, the Center for Energy Efficiency and Renewable Technologies, ENERNOC, that's E-N-E-R, new word, capital N-O-C, Inc., the Coalition to Decommission San Onofre, federal executive agencies, United Public Workers for Action, Energy Producers and Users Coalition. And Mr. Reed, I'm going to give you a tentative party status. I'm not quite convinced that being a PG&E ratepayer that there's a direct interest, but let's see how it goes, and if you find ways that are a substantive contribution, then it'll stay that way. If it's turning out that it's not going to, that you don't have a clear set of information to bring forward in this proceeding, then that status might change.
Well,
okay?
that depends on the scope.
Right.
Obviously.
Right. So at this moment, Mr. Jan Reed, R-E-I-D, also a party. I also have several other additions for information only, which I will not go over in the interest of time. Is there anyone here that I haven't identified who is interested in being a party and who has not filled out a yellow form?
Distribute energy consumer outfits.
Yes. You have a motion, amended motion, which I could not open this morning. Did you by chance bring a hard copy of it? And if so, I'll look at it and come back to you at the end of the proceeding. Okay?
Could you state your name, please?
Michael Dorsey.
I also have a motion from Noble America. Are they here today? All right, I'm going to grant that motion as well. Okay. We have a court reporter making a record today, so it's important that only one person speaks at a time, and please identify yourself first for the benefit of the reporter. If you are looking for a transcript, make sure you filled out the bottom of this yellow form. Want to make sure that all parties understand that they are agreeing to e-file all documents in this case that are required to be filed and served. I'm going to change my usual rule, which is I generally ask for a hard copy. Anything that's filed and docketed, do not send me a hard copy, please. When it comes to testimony, I need 2 hard copies, though. So please keep that in mind. One, because I have to keep a set for the records, and one for my own use. So 2 copies of testimony. Don't give me hard copies of briefs. Or motions or any of that. Okay. Any other questions on parties in the service list?
If I want to add my name, I add it onto one of these and you decide.
Okay, and who are you, sir?
My name's Paul Kangas.
And are you trying to be a party?
Yes.
Or just to get information?
I represent an organization called ONE, O-N-E.
And what is ONE?
It stands for 100% solar power. That's what.
And what's your interest in this proceeding?
Well, it's
briefly.
Briefly, it's that if we shift California to solar, we can avoid having to restart atomic energy plants.
I'm not sure how that's going to fit in with the scope of this proceeding, because I don't anticipate, do you, Commissioner Florio, that we're going to be making a ruling in this proceeding which would require California to move to solar instead of nuclear?
I don't, not in a general way.
Not in a general way. We'll be looking at, this is a very technical cost and operational look at SONGS in 2012 coming into 2013, and in particular the steam generator replacement project.
Right.
So you may not, this is not, the solar PV proceeding. I'm not sure that your interest is of party status here.
Well, it's a replacement concept. I'll give you this and you can think about it.
All right, and I'll ask you to step down.
Thank you.
Mr. Congress, I'm going to put you on as information only. If you if you serve testimony that is relevant to the scope of the proceedings or intend to, you can contact me and ask for that to be converted to party status.
Okay.
All right?
A copy of the statement if you're interested. Can I
No.
submit that with it?
Not right now.
Thank you.
Okay. And Ms. George, you're already part. Okay. So that's it for parties in the service list. Great. Categorization is one of our issues today. This has been categorized at rate setting because the OII is clearly going to review questions of the reasonableness of rates and costs related to the shutdown and the steam generator replacement project. The hearings will be required. There was no dispute about that in the comments and responses. Is there any dispute about that here today? Fine. With respect to the scope of the proceeding, we recognize that utilities and parties have disagreement about to what extent expenses are subject to review in this OII, both as to timing and the type of expense. It's likely we will order briefing on some legal aspects of these questions. We will not be debating them today. However, what we do see is that there are phases that make sense here in terms of building a logical record. Phase 1, which is, you can see reflected by the ruling ordering testimony, we would like to focus on the actions and expenses at San Onofre during 2012. In the GRC, Edison's GRC, which was just concluded, the Commission ordered that the O&M and capital expenditures from 2012 related to songs be tracked in a memorandum account and brought forward by application to be consolidated in this OII. That review of what was reasonable under the circumstances, including community outreach and emergency preparedness, these are the key aspects of Phase 1, and that will include the replacement power costs and avoided costs in 2012. We think this will provide a very good evidentiary record to move into Phase 2, where we will be examining the rate base question presented by Section 455.5 and the post-outage expenses and whether any revenue adjustments are reasonable and just. Phase 3, we would be looking at the steam generator replacement project, the repair and replacement options, and a reasonableness review of the costs associated with the steam generator replacement project. And Phase 4, if necessary, if we continue to have outages and expenses under these facts and circumstances, we would be then looking at the 2013 expenses. And that would include replacement power. So our thinking about the timing is we'd like to move fairly quickly on Phase 1. Edison has been on notice about these expenses, that they are going to be subject to review. We have testimony requests that are scheduled to be served tomorrow. Where are we, Mr. Weissman?
Yes, Your Honor.
How's the testimony coming? Will it be served tomorrow?
It will indeed.
Okay.
As will SDG&E's testimony.
And SDG&E. All right. Now, will you be having a website post of your testimony so it's accessible to the other parties?
May I confirm that, Your Honor? That is my understanding. May I have just a moment to confirm that, please?
Sure.
Thank you, Your Honor.
Off the record. Back on the record?
I'm informed, Your Honor, that there will be an email sent to the service list tomorrow with a link to a web page where this information can be accessed, and that in the future we're developing a more comprehensive website that will make other information available to parties.
Okay, will it work kind of like the general rate case link where you linked into the GRC and you got all the filings?
Yes, Your Honor.
Or the
and so parties to the
May I have
case.
your name, please?
Russell Wyden, 2 S's, 2 L's, W-O-R-D-E-N. And parties will be able to gain access to discovery responses, foundational documents, reports, etc. So forth. Parties who, and that's where public information will be lodged.
Okay.
Items that are subject to non-disclosure agreements, we would handle outside of that.
Okay, fine. Yes, Mr. Giesman.
Your Honor, John Giesman on behalf of the Alliance for Nuclear Responsibility. It was my understanding of your earlier order regarding this web posting that such postings would be accessible to the general public and that one would not need to have party status in order to gain access to the website.
I think that's correct. I just use the term party because that's who participates in the proceeding. But yes, it would be a public post on the website to the extent regarding public documents.
We'll comply with whatever you order.
Okay. You weren't going to screen for parties, were you?
No, Your Honor.
Okay, yes, Mr. Walsh.
If I may, SDG&E will arrange their the availability of our filings and discovery in the same fashion as SCE will be doing.
Okay. All right. Any questions about access to the utility documents? Okay. With respect to these phases that the Commissioner and I have been thinking about, one of the reasons that one of the elements of these phases moving out is that this is going to be a technical proceeding. We're going to be looking very, very closely, drilling down into these costs and expenses and the operational actions and to determine what was just and reasonable. This is not going to be a broad policy debate about whether it's appropriate to have songs operating in 2012 or not, for example. But when we get to rate base and the steam generator replacement project, because these things are quite technical, we anticipate that some of the parties may be contracting with consultants or experts. This gives some time for that to occur. I don't know if Turn and DRA, you often hire experts. Do you have a sense at this point, do you anticipate hiring experts at all or consultants with this?
Yes, Your Honor. We have several consultants that we've already engaged to work on this proceeding.
Okay. Ms. Udisco?
I think that's probably going to depend on what sort of schedule the Commission adopts. At the moment, DRA's main interest is in the immediate removal of the costs from rates.
A little louder, please. A little louder.
I don't know if DRA is going to be seeking a consultant or not. It will probably depend in large part on the schedule that's adopted. In this case, DRA's most immediate concern is the removal of these songs costs from rates.
Okay. I would encourage Turn in particular, since you've already worked with, considered hiring consultants, contemplate doing some coordination with other parties to try to maximize the effectiveness, if you will. I don't know how realistic that is, but it might be worth some kind of meeting or consultation with other parties to see if they have certain angles that might, be coordinated through your expert to try to keep costs down and information as widely dispersed as possible among the parties.
Thank you, Your Honor. We have already begun that consultation process and have met with a number of the groups that are represented here as parties, and that coordination is underway as we speak.
Great. And similarly, Ms. Tedisco of DRA hops on board. Bring everyone along.
Excuse me, Your Honor.
Yes, sir.
Your Honor, Mike Aguirre for Ruth Hendricks. Your Honor, because you're now, I kind of feel like you're starting to concur a little bit and collectively concur a little bit on this issue of phases. So before you get too set in that.
You'll have an opportunity down the, if you want to comment on that.
I would like to comment now because I'm afraid you're getting too far down the road and I'm going to be asking you to take a different turn altogether. Your Honor, there was...
Well, I'll tell you what, sir. I'm going to have you come, I'm going to do one more thing about the scheduling and then I'm going to open it up to comments from the parties.
Fair enough.
Okay? So, in terms of the schedule, our thinking is that we could move in through the first phase in about 6 months, hopefully getting a decision by summer. Right now we have testimony which is to be served tomorrow. DRA and other parties, the initial ruling on this testimony stated that the reply testimony would be due January 29th and rebuttal on February 13th. And then hearings would be in April or May. That's our initial thinking. Phases 2 and 3, because of these experts and consultants, and the Commission may hire its own consultant as well, we would start phase 2 in the summer, hopefully to finish by the end of 2013. That would mean, at that point, time would have occurred, we would know exactly what happened, we would know exactly what's been spent and why, what the thinking was. We would know what the NRC is going to do about the application by Edison to restart Unit 2. We would have more information, hopefully, from Edison about their intentions, and we would also have more information about warranty and insurance coverage that would impact our thinking about allocating any costs to ratepayers versus shareholders. So that's our thinking. That phase on the steam generator costs would occur in 2014. So at this point, I'd like to give parties an opportunity to comment on our preliminary thinking, on the scope and the phasing and so forth, the timing. So,
thank you, Your Honor. Sorry, I had my hand up first. I believe that you were going to acknowledge me. Thank you. Your Honor, Mike Aguirre on behalf of Ruth Hendricks. Your Honor, the preceding 04-02-026 which is the proceeding in which the SGRP was authorized, I think should be our beginning point. And I would urge Your Honor, Winston Churchill said, you define the question, you define the answer. And I'm afraid the way that Your Honor is defining the scope of the proceeding is going to influence whether there's going to be an investigation. The PUC has issued a press release to the people of California, but particularly to those that are within reach of SDG&E and SCE, saying that you're conducting an investigation, not a rate necessarily rate paying or rate setting, which it is, but an investigation to see what happened. Now, there was a proceeding that took place, and in that proceeding, part of the decision was the commission said if the SGRP cost exceeds $680 million, or the commission later finds that it has reason to believe the cost may be unreasonable, regardless of the amount, the entire SGRP cost shall be subject to reasonableness review. That should be the beginning point of the investigation.
All right.
I'm not done.
Well,
excuse me. I need to finish the record, and then you can.
All right. You can have another minute.
Okay. I'm sorry. I didn't realize that you were going to arbitrarily set.
I am going to keep it very short because we have a lot of parties.
Okay.
So
Your Honor,
get a couple of minutes.
So the idea is this: let's go back and pick up where we were when SCE made recommendations and representations about the cost effectiveness of replacing the units, and let's crank in those new numbers. We know from the folks at the NRC that the thermal hydraulic margin was not sufficient to preclude fluid elastic instability. We know that the technical, you say it's going to be technical, we pretty much know that they've already decided that that's the design problem. But in the proceedings, and we're over there reviewing the proceedings, if we go the other way, and Your Honor allows us to start with the record that was made originally, and we pick up with where the commission left off in 2005 when they authorized this, then we can conduct an investigation to find out what was said to the PUC by SCE to determine if it was correct and accurate, both in terms of the reasonableness of cost, as well as the representations about the actual problem of thermal fluid, the thermal hydraulic fluid problem. So that's the recommendation. If you do it the way you're doing it, you're setting it up to accommodate SCE. You're not setting it up to accommodate the public getting an honest investigation underway. And I think, I just ask you to please, I know that that doesn't fit with what your current thinking is, but I ask you to think about the ratepayers and from their perspective, whether what you're describing really is consistent with what you've represented as a commission to the ratepayers in San Diego and in Orange County in the SCE territory that the commission is up to.
Mr. Geary, I think the issues you talked about are within the scope of the proceeding. Are you asking that we incorporate the record of that earlier proceeding into this?
Exactly. And ask Your Honors to make it. That proceeding, incidentally, is not available online. I was just over reviewing the documents. There are 7 sealed and 9 unsealed volumes, and there are 3 sealed exhibit files and 7 sealed. And what I would ask is that as part of the scoping memo that you allow the parties, so long as we sign a protective order, that we sign a protective order so that we can have access to the full record, and that we make a real effort to pick up where you all, where the commission left off from before, because I will tell you, I've reviewed it in pretty extensive detail, and I think it's going to help rather than hurt the proceedings.
Thank you, Mr. Geary. I don't disagree with you. I have read that decision. I am aware that it opens the door to a review of all costs under certain circumstances. I think that the questions you have raised have always been part of the intention of the commissioner and myself as part of the steam generator replacement project review. However, in our view, it is premature to examine those costs because, first of all, we don't have an application yet to review those costs. We have nothing before us. Now, we will be asking Edison to, no. I'm not asking for a discussion here, Mr. Geary.
That's incorrect. No. You're incorrect. There is already, you have that proceeding. No. That proceeding is already in the record. That's part of the decision.
That proceeding is closed, Mr. Geary, and you're finished. let's move on.
Well, what you're saying is inaccurate and untrue.
Mr. Geary, interrupting and arguing with the ALJ is not appropriate in this or any other commission proceeding, and I would advise you to maintain a more professional demeanor. Thank you.
Take exception to those comments.